I want you to picture this. It's April 1968. You're in Washington, D.C., and if you're looking at the photos from that first week, you're not seeing the famous cherry blossoms.
No, you're seeing smoke.
You're seeing smoke rising over H Street. You're seeing members of the 82nd Airborne Division, actual soldiers, patrolling the steps of the U.S. Capitol building.
Machine guns, I mean, it literally looked like a war zone.
And in so many ways it was. The entire country was just convulsing.
Martin Luther King Jr. had been assassinated in Memphis on April 4th.
Right. And in response, you have more than 100 American cities that are, for all intents and purposes, on fire. And yet inside the Capitol building, while they can literally smell the smoke in the air, Congress is in this frantic race.
A frantic race to pass a piece of legislation that, frankly, felt completely impossible just a week earlier.
It was crisis legislation. And today, we're doing a deep dive into what came out of that fire. We're talking about the Civil Rights Act of 1968.
Now, when people hear Civil Rights Act, they usually think of the big one.
The 64 Act.
Exactly. The one that ended segregation in restaurants, hotels, public spaces. Or they think of the Voting Rights Act of 65. The 68 Act, though, it's kind of the forgotten one.
Or it gets reduced to a single nickname. People just call it the Fair Housing Act.
Which is true. It is the Fair Housing Act. But, you know, that's kind of like saying an iPhone is just a calculator.
Yeah, that's a great way to put it. It does that one thing really well, but it does so much more.
Right, it does the calculation, but it also runs your entire life. The 1968 Act is this sprawling, almost bizarre legislative Swiss Army knife.
I've been reading through the actual text, and it feels like a Frankenstein's monster of a bill. It feels like three totally different laws that were just stapled together in a panic.
And what are the three parts?
Okay, so you've got Title VIII, which is a famous part. That's fair housing. It's about ending discrimination, opening up the suburbs. But then, buried right in the middle, you have Titles II through the VII, which completely rewrote the legal relationship between Native American tribes and the U.S. government.
Something most people have no idea is in there.
Absolutely not. And then, tacked on at the end, you have Title I and Title X. And these are basically a federal crackdown on hate crimes and riots.
It seems so disjointed at first glance. Housing, tribal law, riot control, what's the connection?
But when you step back, you see this underlying theme, right?
Mm-hmm.
It's this tension between federal power and, for lack of a better word, local sovereignty.
Whether that local entity is a white suburban neighborhood that doesn't want to integrate.
Or a Native American tribe trying to govern itself.
Or even a political protest group in the streets. This law was the federal government in one single week asserting its will over all of them at the same time.
So that's our mission for this deep dive. We're going to unpack this beast. We're going to figure out how these three incredibly different concepts, housing justice, tribal sovereignty, and riot control all, ended up in the same document that LBJ signed into law on April 11th, 1968.
And to do that, you have to start with the context, because this wasn't a bill that was, carefully debated over tea and crumpets in some quiet chamber.
No, this was forged in a pressure cooker.
An absolute pressure cooker.
So let's talk about that pressure cooker. Because before that week, in April 1968, a federal fair housing bill was completely dead in the water.
Oh, it was worse than dead. It was the political third rail. You didn't touch it.
We hear it was hard to pass, but I don't think people realize how hard.
Well, listen to this. This is a quote from Senator Walter Mondale, who was the bill's main sponsor in the Senate. He later called it the most filibustered legislation in U.S. history up to that point.
The most filibustered?
Yeah.
More than the 64 Act.
More than any of them. He was just incredibly frustrated. And you have to put yourself in his shoes. The civil rights movement had all this incredible momentum in 64 and 65. They broke the back of legal Jim Crow in the South. But then they got to housing.
And they just hit a wall.
A complete wall.
So why? I mean, why was housing so much harder? It feels like if you can force a lunch counter in Alabama to serve everyone, you should be able to force a landlord in Chicago to do the same.
And that's the key right there. You said Alabama and Chicago. Walter Mondale had this very sharp, maybe a little cynical, but very accurate insight on this.
What was it?
He pointed out that the 1964 and 1965 acts were, fundamentally, the North telling the South what to do.
Right. It was about fixing their problem.
Exactly. It was easy for a senator from, say, Illinois or New York to vote for the Voting Rights Act. His constituents were already voting. The bill was about fixing those racists down there in Mississippi or Georgia.
It's a morality play, and the villain is someone else, somewhere else.
Precisely. But the Fair Housing Act, that wasn't about the South. That was about Chicago. It was about Detroit, New York, Los Angeles, Philadelphia. It was about the suburbs everywhere.
It was coming home.
Mondale's words were, "This came right to the neighborhoods across the country. This was civil rights getting personal."
So as soon as the conversation shifted to who could buy the house next door to you,
Suddenly, those very liberal northern political coalitions started to get very nervous. They started to fracture.
it's the classic NMBY problem, right?
Yeah.
Not in my backyard, just on this massive racialized scale.
Absolutely. And you had powerful forces mobilizing against it. The National Association of Real Estate Boards, which, is the predecessor to today's National Association of Realtors, they weren't just lobbying in D.C., they were weaponizing white homeowners.
How so?
They were funding campaigns built on fear, spreading the idea that if the government could tell you who to sell your house to, property values would collapse. That forced integration was a threat to your biggest investment.
And this wasn't just talk. It actually killed a bill before '68, didn't it?
It did. There was a proposed Civil Rights Act of 1966. It was a big, ambitious bill, but the housing provision was its poison pill. It failed spectacularly, largely because of that opposition. The issue was just politically radioactive.
Okay, so let's fast forward. It's early 1968. The bill is stuck in the Senate. It's being filibustered. Everyone, including its supporters, basically expects it to die a quiet death. What happens? What breaks the gridlock?
Two massive shocks to the system. The first one lands in March of '68. You get the Kerner Commission report.
And remind us, what was the Kerner Commission?
So this was the government's official investigation into what was called the Long Hot Summer of 1967.
Right, when cities like Newark and Detroit had these huge, destructive riots.
Yes. And President Johnson put together this commission, headed by Governor Otto Kerner of Illinois, to figure out why. Why is this happening? And the report they came back with absolutely terrified white America.
What was the conclusion?
The most famous line from the report is this: "Our nation is moving toward two societies, one black, one white, separate and unequal." It was this brutal, honest assessment.
And did they specifically connect this to housing?
They drew a direct, unmissable line. They basically said that decades of housing segregation, of redlining, had created the ghetto conditions that were now exploding into riots. They explicitly recommended a national open housing law as a solution.
So that primes the pump. It puts the idea out there that fair housing isn't just about fairness, it's about national security.
It's about preventing the country from tearing itself apart. So that's shock number one. But the spark, the absolute tragedy that blasted the door off its hinges came on April 4th.
Martin Luther King Jr. is assassinated.
And the timeline from this moment on is just staggering. It's one of the most compressed and consequential weeks in American legislative history.
So let's walk through it day by day. April 4th, Thursday, King is shot on a motel balcony in Memphis.
And chaos erupts almost immediately. The King assassination riots, as they came to be called, break out in over 100 cities, and D.C. is one of the worst.
So April 5th, Friday, Washington is literally on fire.
Right. And President Johnson, seeing this unfold, writes a letter and sends it to the House of Representatives. And he's not asking nicely anymore. The tone is completely different. He is demanding that they pass the Fair Housing Act, framing it as both a tribute to Dr. King's legacy and as the only way to quell the violence in the streets.
He's using the crisis as leverage.
Maximum leverage. Now, the bill at this point had passed the Senate, but it was stuck in the House Rules Committee.
Which is where bills usually go to die, right? The chairman can just sit on it forever.
Exactly. The committee had been sitting on it, refusing to let it go to the floor for a full vote. But then comes Monday, April 8th, and the historical records have this amazing description of the meeting. They say the committee members were jolted by the repeated civil disturbances virtually outside its door.
They could hear it.
They could hear the sirens. They could smell the smoke from their offices. This was no longer an abstract debate about property rights. It was about the survival of the city they were in.
It's amazing how quickly political conviction can evaporate when the building you're in starts to shake.
Fear is a very powerful motivator in politics. So on April 8th, they suddenly end the hearings and release the bill to the floor.
2 days later, April 10th, the full House votes.
They pass it, 250 to 172. And the very next day, April 11th, President Johnson signs it into law.
1 week. 7 days from assassination to enactment. That's just incredible.
It's unheard of for a piece of legislation that controversial.
And looking at that final vote count, 250 to 172, that's not exactly a landslide victory.
No, and the breakdown of that vote is fascinating. It wasn't a clean party line split, which tells you how complicated the issue was.
How did it break down?
Democrats voted 150 in favor and 88 against. So a lot of Southern Democrats still voted no. And the Republicans were almost evenly split. 104, 84 against.
So this was a coalition of Northern Democrats and moderate Republicans all pushed into action by the crisis.
It was a coalition of the willing, driven by a profound sense of urgency. I think it's safe to say that without the tragedy of King's death and the riots that followed, we almost certainly would not have the Fair Housing Act of 1968.
Which is deeply ironic given that a big part of the bill is an Anti-Riot Act, which we're going to get to.
A huge irony.
But let's start with the crown jewel. Let's dig into Title VIII, the Fair Housing Act itself. What did it actually do?
Okay, so this is the part of the law that really changed the face of American real estate. At its core, it was about ending discrimination in the sale, rental, and financing of housing.
And originally, it established 4 protected classes, right?
That's right. The original text from 68 covered race, color, religion, and national origin.
And the prohibitions are pretty broad.
They were. It made it illegal to do the obvious things, like refuse to sell or rent to someone because of their race. It also made it illegal to lie and say an apartment was already rented when it wasn't, which was a common tactic.
Sorry, it's already gone line.
Exactly. But importantly, it also went after the machinery of housing segregation. It didn't just target individual bigots, it targeted discriminatory business practices.
And the big one there was something called block busting.
Yes.
I've read about this, and it just sounds like a predatory con game. Can you walk us through how block busting actually worked on the ground in a real neighborhood?
It was purely predatory. So let's say you have a stable, middle-class white neighborhood in, say, the 1950s or 60s. A real estate agent, who we'd call a blockbuster, would move in to deliberately destabilize it for profit.
How would they start?
They'd use these really insidious tactics. They might hire a black woman to walk down the street pushing a baby in a stroller, or they'd pay a few black teenagers to stage a loud, fake fight on a street corner.
Just to create a visible presence.
A visible and deliberately scary presence. Then that same agent goes door to door to the white homeowners and says something like, "Did you see what's happening? They're moving in. The whole neighborhood is about to turn. I've seen it happen before. Your property values are going to crash. You need to sell to me now while you can still get something for your house."
So they're manufacturing a panic,
Right.
inducing panic selling.
Exactly. They get the terrified white family to sell their house at a rock bottom, below market price.
And then what?
Then they turn right around and sell that exact same house to a black family. But because that black family has been systematically shut out of other neighborhoods by redlining and restrictive covenants, their housing options are severely limited.
So they're desperate.
They're desperate. And the blockbuster exploits that desperation, selling them the house at a massively inflated price, often with very predatory contract terms.
So the agent is profiting on both ends of the transaction.
Huge profits on both ends. And in the process, they destroy the neighborhood's social fabric and drain all the equity out of it. Title VIII of the 68 Act made those specific representations going door to door and trying to induce panic based on race illegal.
That's a really crucial piece of consumer protection that's disguised as a civil rights law.
It absolutely is.
But the law didn't just stop there in 1968. It evolved. It grew over time.
It had to. Society changed. In 1974, Congress came back and added sex as a protected class. This was a huge step for single women, divorced women who were often denied apartments or mortgages.
And then there was an even bigger expansion later on.
Yes. The biggest changes came in 1988 with the Fair Housing Amendments Act. That's when we added 2 more crucial categories: familial status and disability.
Familial status sounds like legal jargon. That just means you can't discriminate against people with kids.
That's the main thrust of it, yes. Before 1988, adults-only apartment complexes were perfectly legal and very common. Landlords could just flat out say, "We don't want the noise, we don't want the hassle, no children allowed."
And the amendment made that illegal.
It did, with one major exception. You can still have senior housing, like a 55-plus retirement community, but general-purpose apartment buildings can no longer ban kids. The protection also extends to pregnant women and people in the process of adopting.
Okay, but the disability protections added in 88. This is where the law gets really technical and interesting. It's not just a negative command like don't discriminate. It actually creates a positive duty for landlords to do things.
That's right. It creates an affirmative duty on the part of the housing provider. And we usually divide this into 2 buckets: reasonable modifications and reasonable accommodations.
Let's drill down on modifications first. This is the physical stuff, the bricks and mortar.
Correct. So let's take a classic example. A tenant uses a wheelchair, and the doorway into the bathroom in their apartment is too narrow for the chair to fit through. Under the Act, the landlord must allow the tenant to modify the unit by widening that doorway. They can't just say, no, you can't change my property.
But who pays for it? Does the landlord have to pay to widen the door?
And this is the critical part. Generally, no. The tenant has to pay for the modification themselves.
Okay, so I'm the tenant. I pay a contractor a few $100s to widen the door. I live there for 5 years, and then I decide to move out. What happens then? Does the landlord just get a free, upgraded, more accessible apartment?
Maybe, but here's the nuance. The landlord can require you to restore the unit to its original condition when you leave, if the modification would interfere with the next tenant's use or enjoyment of the apartment.
Wait, hold on. How would a wider doorway interfere with the next tenant? If anything, it seems like a benefit.
And you've hit on the exact legal test. In the case of a widened doorway, it almost certainly wouldn't interfere. The regulations say that if the modification doesn't affect the usability for the next person, the landlord can't require you to restore it.
But what's an example of something I would have to change back?
Let's say you're in a wheelchair and you pay to have all the kitchen cabinets and countertops lowered by a foot so you can reach them. That might very well interfere with the next tenant, who might be 6'4" and can't comfortably use that kitchen.
Okay, that makes sense.
So in that case, the landlord could require you to put the cabinets back at their original height when you move out.
And I remember reading something about an escrow account. How does that work?
Yes, this is another protection for the landlord. If the restoration is going to be expensive, the landlord can actually require the tenant to pay a little extra money each month into an interest-bearing escrow account.
To save up for the future repairs.
Exactly. So the money is guaranteed to be there to restore the apartment when they leave.
Wow. That seems like a really high hurdle for a low-income tenant with a disability to clear.
It is. It's a compromise written into the law. The law grants the right to access, but it doesn't always provide the funding to achieve it.
Okay, so that's modifications. What about the other bucket? Accommodations.
So accommodations are about changing rules, policies, or procedures, not physical structures.
Give me the classic example.
The classic example is the no pets policy. An apartment building says absolutely no pets allowed, but a person who is blind applies to live there and they have a seeing eye dog.
The dog has to be allowed.
The landlord must make a reasonable accommodation and waive the no pets rule for that assistance animal. And they can't charge a pet fee or a pet deposit because it's not a pet. It's a medical aid.
What about parking? I feel like parking disputes are the #1 cause of strife in apartment living.
A huge area for accommodations. Let's say your building has a first-come, first-served parking lot, no assigned spots. But a tenant has a mobility impairment that makes it very difficult for them to walk long distances.
So they need a spot near the door.
Right. They can request an accommodation, and the landlord would be required to assign them a specific reserved parking space close to their unit, even though no one else gets an assigned spot. That's a change in policy.
So the law is pretty comprehensive, but it's not universal. We have to talk about the big loophole, the Mrs. Murphy exemption.
Ah, yes. Mrs. Murphy's boarding house.
When I first heard about this, I seriously thought it was an urban legend. But it's real.
It's very real. The name actually comes from the legislative debates around the bill. The idea was to protect a hypothetical elderly widow, a Mrs. Murphy, who rents out a spare room in her own home to make ends meet. The question was, should the federal government be able to force her to live with someone she's not comfortable with?
Congress decided no.
They decided no. They wanted to balance civil rights with an individual's right to privacy and association within their own home.
So what's the specific rule? How does the exemption work?
Okay, it's a two-part test. First, the building has to have 4 or fewer units. And second, the owner of the building has to live in one of those units.
So a duplex, a triplex, or a fourplex where the owner is also a resident.
Exactly. If both of those conditions are met, the owner is exempt from the Fair Housing Act's non-discrimination standards when they choose their tenants.
Let me be really clear about this. If I own a fourplex and I live in Unit A, I can legally tell a prospective tenant for Unit B, I'm sorry, I'm not renting to you because you're Muslim or because you're black.
Under federal law, in that very specific scenario, yes, you can make that discriminatory choice. However, and this is a massive, massive asterisk that trips up a lot of small landlords.
That's the catch.
The exemption only applies to the final selection of the tenant. It does not apply to discriminatory advertising.
Explain that distinction. That's huge.
So you, the owner-occupant of the fourplex, can discriminate in your head and in your final decision. But you cannot place an ad on Craigslist or in the local paper that says no kids or Christians only. Title VIII's ban on discriminatory advertising applies to everyone, even Mrs. Murphy.
That seems psychologically contradictory. The law is saying you can be a bigot, you just can't announce it publicly.
That's a good way to put it. The law is trying to prevent the public humiliation and the creation of a hostile, segregated marketplace, while still preserving that small sliver of private right to choose who literally sleeps under your own roof. It's a very fine line.
And speaking of fine lines and modern interpretations, let's talk about LGBTQ plus rights. The words sexual orientation and gender identity are not in the text of the 1968 Act.
They are not. But the word sex is. And this is a perfect example of how a law passed decades ago can live and breathe and adapt to new social and legal understandings.
So for a long time, courts just interpreted sex to mean biological, male or female.
For decades, yes. But the tectonic plates of legal interpretation shifted in a huge way in 2020 with a Supreme Court decision called Bostock v. Clayton County.
Right, that was a big employment discrimination case.
It was an employment case, not a housing case. But the logic it established was revolutionary. It was a 6-3 decision, and Justice Neil Gorsuch, a conservative, wrote the majority opinion.
And what was his reasoning?
It was this really elegant piece of textualism, basically a logic puzzle. He said, imagine you have two employees who are both attracted to men. One is a woman, one is a man. If you fire the male employee for being attracted to men, but you don't fire the female employee for being attracted to men, then you have made a decision that is based, in part, on the employee's sex.
You can't separate the two.
You can't. He argued that to discriminate against someone for being gay or transgender, you necessarily have to take their sex into account. Therefore, it is a form of sex discrimination.
It's a logic gain that results in protection.
A brilliant one. And almost immediately after that decision, people started asking, well, if that's what sex means for employment law, doesn't it have to mean the same thing for housing law?
And the Biden administration said yes.
They did. In February of 2021, the Department of Housing and Urban Development, or HUD, issued a formal directive. It said that, based on the Supreme Court's reasoning in Bostock, HUD will now enforce the Fair Housing Act to prohibit discrimination based on sexual orientation and gender identity.
So as of right now, LGBTQ plus status is effectively a protected class in housing.
Correct.
But it's not because Congress passed a new law. It's because we are rereading a single word sex that's been in the law since 1974.
Exactly. And that's an important distinction. Because it's based on an administrative interpretation and a Supreme Court case, it could theoretically be reversed by a future court or a different administration. It's legally solid for now, but it's not codified in stone the way race or religion are.
Okay, this is a perfect place to pivot. We've talked about the suburbs and apartments. Now we need to leave all that behind and head to the reservation. This is the part of the bill that, I have to admit, completely shocked me. Titles 2 through 7th, also known as the Indian Civil Rights Act of 1968.
This is the forgotten middle child of this legislation, absolutely.
My first question is just, why? Why is a law that we associate with Martin Luther King and fair housing suddenly dealing with the intricacies of tribal courts?
Because it was designed to solve a massive legal paradox, a rights vacuum that had existed for nearly a century.
Okay, you have to go back in time for us.
We have to go back to 1896. There was a Supreme Court case called Talton v. Mays. And in that case, the court laid out a really strange but powerful doctrine. They ruled that because Native American tribes are distinct, independent political communities, essentially, sovereign nations that predate the Constitution, the U.S. Constitution does not apply to them.
Wait, stop there. So if I were a member of the Navajo Nation living on a reservation in, say, 1960, the First Amendment's guarantee of free speech didn't protect me.
Not from your tribal government. The Bill of Rights was written to limit the power of the federal government. Later, the 14th Amendment applied most of those rights to limit state governments. But a tribe is neither a state nor the federal government.
It's a third sovereign.
It's a third sovereign. So if a tribal council in 1960 wanted to ban a certain newspaper or seize your property without due process, or establish an official religion, the U.S. Constitution had absolutely nothing to say about it.
That's a huge black hole for civil rights.
It was an enormous vacuum. And by the 1960s, Congress started holding hearings, and they heard absolute horror stories. The official committee reports use the phrase, corrupt, incompetent, or tyrannical tribal officials. There were stories of people being banished or having their property taken with no recourse. Congress felt it had to step in.
So they passed the Indian Civil Rights Act, or ICRA,
Yeah.
as part of this big 1968 package. Did they just copy and paste the U.S. Bill of Rights and apply it to the tribes?
Mostly, but not entirely, and the omissions are just as important as the inclusions. They did grant Native Americans on reservations most of the big protections. Free speech, freedom of the press, freedom of assembly, protection from unreasonable search and seizure, from double jeopardy, the right to a speedy trial. All the greatest hits are in there.
But what did they leave out?
They made some very specific, intentional omissions to try and respect tribal culture and sovereignty.
Like what?
For one, they left out the Establishment Clause.
That's the part of the First Amendment that creates the separation of church and state.
Right. And they left it out because many tribal governments are, for lack of a better word, theocratic. Their system of governance and their spiritual leadership are often one and the same. If you forced a strict separation of church and state on them, you would effectively dissolve the traditional structure of their tribe.
So ICRA allows for that to continue.
It does. Another big omission has to do with lawyers in criminal cases.
Okay, in a U.S. court, under Gideon v. Wainwright, if you're poor and accused of a serious crime, the government has to provide you with a lawyer.
Correct. Under ICRA, a tribal member has the right to a lawyer, but only at their own expense. The tribal government is not required to provide a public defender.
That's a massive difference. What was the reasoning?
Purely financial. Congress realized that many tribes were very poor and simply did not have the money or the infrastructure to fund a public defender system. Requiring them to do so would have bankrupted their governments.
So they were trying to thread this very delicate, needle-granting individual rights, but also trying to preserve the tribe's ability to function as a sovereign entity.
That was the goal. But then came the court case that blew this whole arrangement wide open and really defined what ICRA means today.
And that's Santa Clara Pueblo v. Martinez.
A landmark case from 1978. It's a tragic story, but it is a masterclass in this conflict between individual rights and collective sovereignty.
So introduce us to the woman at the center of this,
Yeah.
Julia Martinez.
Julia Martinez was a full-blooded member of the Santa Clara Pueblo tribe, located in New Mexico. She lived her whole life on the reservation. She fell in love with and married a man who was Navajo, another Native American, but not a member of her specific tribe.
Yeah.
They had children and raised them on the Santa Clara Pueblo reservation. But the tribe had an old membership ordinance dating back to 1939. And this ordinance said that if a female member of the tribe marries someone from outside the tribe, her children are not considered members of the Santa Clara Pueblo.
But what about the men? What if a Santa Clara man married an outsider?
If a man married an outsider, his children were automatically granted tribal membership. It was strictly patrilineal.
That is the most textbook, clear-cut case of sex discrimination I have ever heard. And you just told me that the ICRA explicitly guarantees equal protection of the laws.
Exactly. And that was her argument. Julia Martinez sued the tribe. She argued that this membership rule violated her rights under the Indian Civil Rights Act. And this wasn't just about a title. It had real-world consequences. Her children couldn't vote in tribal elections, they couldn't hold office, and crucially, they couldn't inherit her home on the reservation.
So when she died, her kids could have been evicted from the house they grew up in.
That was the fear.
This sounds like an open and shut case. Federal law says equal protection. The tribe's rule is a clear violation. She should win.
And that's what the lower courts wrestled with. But when the case got all the way to the U.S. Supreme Court, the legal question shifted. The question before the court wasn't, is this rule sexist? Everybody knew it was. The question became, who gets to decide if it's illegal?
The tribe or the federal courts?
Precisely. And in a 7-1 decision, the Supreme Court ruled against Julia Martinez.
Why? What was the logic?
The court's majority, led by Justice Thurgood Marshall, said that while Congress passed the ICRA and granted these rights, it did not explicitly create what's called a private cause of action in federal court to enforce them.
Can you translate that legal jargon for us?
They basically said, yes, you have these rights on paper, but the only place you can go to enforce them is a tribal court. The Supreme Court held that allowing a tribe to be sued by its own members in a U.S. federal court would be a massive intrusion on their sovereignty. It would undermine their status as self-governing nations.
So they prioritized the sovereignty of the group over the civil rights of the individual.
They did. They essentially ruled that a tribe has the sovereign right to define its own identity, to decide who is and who is not a member, even if that definition appears discriminatory by outside American standards.
Oh, so the federal government gave with one hand and took away the enforcement mechanism with the other. They said, here's a list of your rights, but good luck getting your tribal council to enforce them if they're the ones violating them.
That is the central paradox of the ICRA today. It stands as a powerful statement of values. But because of the Martinez decision, federal courts will generally not get involved in internal tribal civil rights disputes. The tribe's own court system is the final word.
It's a really powerful reminder that sovereignty isn't just a flag or a name. It's the power to make your own rules and even the power to be wrong by someone else's standards.
Or, as the tribe would argue, the power to be different. They argued that their control over lineage and membership was essential to their cultural survival. If the federal government could dictate who's a member, they would cease to be a distinct people.
Okay, we need to move to the third and final pillar of this act, the one that deals directly with the fire and the fury of 1968. We're talking about Title I and Title X, the hate crimes and anti-riot provisions.
Right. And you have to see these two sections as the political trade-off. This was the law and order meat that was thrown to the conservative members of Congress to get them to vote for the fair housing part of the bill.
Let's start with Title I. This created a new category of federal hate crimes.
It did. It made it a federal crime to injure, intimidate, or interfere with someone because of their race, color, religion, or national origin. But, and this is a key detail, there was a catch.
What was the catch?
The victim had to be engaged in one of a specific list of federally protected activities at the time of the attack.
Okay, so what's on that list? What counts as a federally protected activity?
Things like voting or campaigning for a candidate, attending a public school, applying for a job, serving on a jury, traveling from one state to another.
Things that have a clear federal government interest.
Exactly. But the biggest one, the one that covered the most ground in daily life, was enjoying the goods, services, or facilities of any place of public accommodation.
So, eating at a diner.
Eating at a diner, staying at a motel, going to a movie theater.
So let me get this straight. If you assault someone on the street because they're black, that's a state-level crime handled by local police. But if you assault someone inside a restaurant because they're black and they're trying to order a sandwich, that is now a federal felony under the 1968 Civil Rights Act.
You've got it perfectly. That brings the FBI into the investigation.
And that was the whole point, right? To bypass local law enforcement in the South that was often unwilling or unable to prosecute these kinds of crimes.
That was the entire point. It gave the federal government jurisdiction.
Okay, but then we get to Title X, the Anti-Riot Act. This is the section that feels like it was written with a laser focus, directly targeting the people who were protesting in the streets.
It absolutely was. In fact, it was unofficially known as the H. Rap Brown Law.
Okay, we hear that name a lot in this context, but who was H. Rap Brown?
So H. Rap Brown took over as the chairman of the Student Nonviolent Coordinating Committee, or SNCC, after Stokely Carmichael. He was a very prominent and fiery Black Power advocate, much more militant in his rhetoric than someone like Dr. King.
And why was the law named after him?
In the summer of 1967, he gave a very inflammatory speech in Cambridge, Maryland. A riot broke out in the town shortly after the speech. He was later arrested on federal charges for carrying a gun across state lines while he was under indictment for inciting that riot.
And this played right into the dominant narrative at the time of the outside agitator.
The perfect narrative. You had Southern governors and big city mayors who loved to claim that their local Black populations were perfectly happy and content, and that all the riots and unrest were being caused by these outside agitators, communists, radicals from the North who were parachuting in just to stir up trouble.
So Title X essentially turned that political narrative into a federal crime.
It did. It made it a felony to use interstate commerce, which means to travel or use the mail or the telephone or a radio broadcast with the intent to incite, organize, promote, encourage, or participate in a riot.
That phrase, interstate commerce, is doing a lot of heavy lifting in that sentence.
It's the hook that gives the federal government power. And today, of course, that includes the internet. If you send a tweet or a Facebook post from one state to another trying to organize a protest that turns violent, you are theoretically in the crosshairs of this law from 1968.
But this seems to run headlong into the First Amendment. Where do you draw the line between a passionate, fiery political speech and the crime of incitement?
And that has been the huge legal battleground ever since. There's a very famous legal standard from a 1969 Supreme Court case called Brandenburg v. Ohio.
Just a year later.
Just a year later. And the Brandenburg test says you can't punish inflammatory speech unless it is directed to inciting imminent lawless action and is likely to produce such action.
Can you break that down?
So standing on a stage and saying, we need a revolution, we should burn this corrupt system down eventually, is generally protected speech.
Okay.
But pointing to a specific building and saying, let's go burn that courthouse down right now, is incitement. It's the difference between advocating an abstract idea and inciting an imminent, specific crime.
And the courts have had to apply that standard to the Anti-Riot Act.
They have, and it's been a struggle. In fact, very recently, in 2020 and 2021, two different federal courts of appeals, the Fourth Circuit and the Ninth Circuit, actually struck down parts of this law as unconstitutional.
Really? Which parts?
They looked at the list of verbs in the statute. One of them was to urge a riot. And the court said, no, the word urge is too vague. It's too close to constitutionally protected political advocacy. So they struck down the part of the law that banned urging a riot.
But they kept the other parts.
They did. They upheld the bans on inciting, organizing, and participating. So if you're a protest organizer today, you have to be very careful with your verbs.
And this law isn't just a historical artifact. It's still being used.
Oh, absolutely. Federal prosecutors used it against some of the protesters during the widespread demonstrations in 2020 after the murder of George Floyd. It is still a very live wire in American law.
Okay. So let's zoom out. We have this massive, complicated document. It opened up the suburbs with Title VIII. It applied a modified Bill of Rights to Native American tribes with the ICRA. And it criminalized the very riots that helped get it passed with Title X. 50-plus years later, what's the legacy? Did it work?
It's such a mixed bag. And you almost have to evaluate each part separately.
So let's start with housing. That's the part people know best.
On one level, it was a profound success. It officially ended the era of legal, overt housing discrimination. Those whites-only signs came down. You could no longer run a classified ad that said no Jews. That world is gone, and that is a direct result of this law. But the weak link has always been enforcement.
Because the government doesn't have an army of inspectors checking every single lease application in the country.
Exactly. The system relies heavily on what lawyers call private attorneys general. The law is designed for individual victims of discrimination to go out, hire their own lawyers, and sue the landlord or the real estate company. It creates a private solution to a huge public problem.
And that assumes the victim knows their rights, has the time and the emotional energy to pursue a lawsuit.
And has the money to hire a lawyer, though the 1988 amendments did help by allowing successful plaintiffs to recover their attorney's fees. But just look at the raw numbers. HUD itself estimates that there are around 2 million instances of housing discrimination every single year in America. The National Fair Housing Alliance, a private group, puts the number closer to 4 million.
4 million. And how many of those actually result in a formal complaint?
A tiny, tiny fraction, maybe 25,000 or 30,000 a year.
Because the discrimination isn't overt anymore. It's what people call smile discrimination.
That's the perfect term for it. The landlord smiles, shakes your hand, seems very friendly, and then says, oh, I'm so sorry, we just rented that unit 10 minutes ago. How do you prove that was a lie based on your race without going through the trouble of hiring testers to check your story? For most people, you can't.
And there's an even deeper, more systemic critique of the law's success, right? That even if you get the apartment.
Exactly. Housing advocates like Elizabeth Julian and Michael Daniel have made this point very powerfully. They say the act focuses on achieving a unitary housing market where money is the only barrier. But that's not enough.
What do they mean?
So let's say the law successfully stops a landlord from denying you an apartment because of your race. But the landlord is still allowed to deny you because you have a low credit score or a minor criminal record from your youth.
And if historical and systemic factors have made it more likely for certain racial groups to have lower credit scores or a criminal record,
then you've just laundered the discrimination through a seemingly neutral, objective spreadsheet.
you haven't solved the problem, you've just changed its name.
Precisely. And they make another point. Opening the door to a neighborhood doesn't fix the neighborhood itself. If a low-income minority family uses a housing voucher to move into a certain area, but that area has crumbling schools, lead pipes, no grocery stores, and high crime rates, well, the Fair Housing Act didn't cause those problems, but it didn't solve them either. It just gave you equal access to a disadvantaged place.
Before we wrap this all up, there was one small, almost poetic detail that you found buried in the text of the law that I wanted you to share.
Yeah, this is a real deep cut. It's in Title VII, right in the middle of the Indian Civil Rights Act. And it's just this one sentence where Congress officially recognizes the centennial of the 1868 Treaty of Peace between the Navajo tribe and the United States.
100 years, 1868 to 1968.
And you have to know what that 1868 treaty was. That was the treaty that allowed the Navajo people to return to their ancestral homeland after the Long Walk, which was their forced removal and exile by the U.S. Army, a brutal, traumatic event in their history.
And exactly 100 years later, Congress is passing this law.
It's this moment where the timeline just folds in on itself. You see this 100-year arc, from forced exile to a treaty recognizing their homeland to a federal law in 1968 that's trying to redefine what their sovereignty even means.
It really shows you that history isn't a straight line. It's a circle. It's a cycle.
And we are all still living inside that cycle.
So that's the Civil Rights Act of 1968. It's so much more than just a housing law. It's really a snapshot of a nation at a breaking point in April of 1968. A nation that was terrified of riots, grieving a martyr, trying to fix the suburbs, and trying to figure out its relationship with Native nations, all in one chaotic, contradictory document.
It's a legislative Swiss Army knife, forged in a fire, that we are still pulling out and using every single day, whether we realize it or not.
And so here's a final provocative thought for you to chew on as we finish. The act was designed to stop individual acts of discrimination. A landlord saying, "I won't rent to you because of your race." But it wasn't really designed to fix the systemic inequality that made you more likely to have bad credit in the first place.
It treats the symptom, not the disease.
So the question is, if we achieve a world where everyone has an equal opportunity to rent an apartment, but we still have vast historically driven inequality in the ability to pay that rent, is that justice? Or is that just capitalism working with perfect, brutal efficiency?
That is the question that the law itself can't answer. That's the one that's left for us to figure out.
Something to think about the next time you walk through your own neighborhood and consider how it came to be. Thanks for joining us for this deep dive.
We'll see you next time.